All right, here we go. Hi, this is Curt
and Brad Pinsky.
And we are here for another edition of Fire Law Roundup for May 22nd of 2023. Brad, go ahead. Take us away.
Let's start in New York State because why not? I'm here. And this is a really insane one to me. I'm not sure how this happened, but we have in the Putnam Valley, which is kind of eastern New York for those trying to locate it. We call it the Hudson Valley area. This department builds a new firehouse, and normally, as many people know, you put fill in once you got footers and foundation work and everything. And the contractor comes and brings, let's call it contaminated fill, right? Hard fill, which is contaminated and has to go to a special landfill site. And so, and it's like parts of like furnaces and doors and insulation and.
They referred to it. You know what they referred to it in the complaint as? They called it urban fill.
Yeah,
it's like what's left over after we burned down a couple of buildings in the city,
right?
Urban fill.
I don't understand. It's obviously a huge DEC violation, and they just start dumping it as part of this foundation. By the way, it's not even structurally sound, right? You put a furnace, a tank, which is hollow, and it's going to crush. In any event, it's contaminated. You can't do it. It's a huge violation. They sue under CERCLA, as we refer to it, but it's a federal law that allows you to sue for these types of things. The problem, my fear for the fire department's totally right. I have questions like, how did no one see a bunch of this stuff sticking out? This isn't like contaminated soil where you'd have to figure it out. This is big pieces of fill that any person would notice shouldn't be there, right? You don't dump garbage.
Yeah, I think they did. And the kind of complaint walks you through it. They hired a specialist. They hired a hazmat specialist to come in. Of course, I'm sure the contractor is denying it. So now you have
the stuff magically appeared there.
Right, fire department saying this is contaminated. The contractor saying, "Oh no, there's no problem," and so they hired a consultant to come in, did the testing, and then they, I think the fire department did it right. They worked with DEC, the Department of Environmental Conservation. That's a state agency in New York, but they work with them and sort of hand in hand and said, "We got to clean this up." And the price tag, I couldn't believe, 1.75 million, and it still is increasing from there because they still have some cleanup issues.
And the landowner's liable for this because they effectively, I don't know why they pled to it. In your recitation, you say, well, they pled, but they admitted, I guess,
they entered into a consent agreement with DEC. So I'm not sure that there was a separate litigation. But by the way, that CERCLA, let me get the right, Comprehensive Environmental Response Compensation and Recovery Act, that is what allows fire departments to sue. Like when we go on a response, that's what allows us to recover the costs associated with hazmat response. So in this case, it's one of those things that held the fire department responsible as the property owner.
Yeah, and it's crazy because, right, if you think, well, how are we the responsible party? Effectively, because they're operating a landfill, DEC would say. And did say, and that's the agreement. So, my fear is this probably isn't covered by anybody's insurance.
No, I wouldn't imagine, unless you have a really good insurance policy that covers that. But most well-written insurance policies from the insurance company's perspective is going to exclude something like this. Right.
This is not like an accidental spill or something. I mean, this is, effectively, well, they said they operated a landfill by taking this stuff, which I'm sure it wasn't their intent. But my real concern is for the fire department and its municipality is, are you going to really get this from the contractor? There's not a lot of contractors who have $1.75 million. Now, I'm sure there's a criminal component to this. And as part of the criminal component, right, there will be, because DEC violations are criminal, some of them. And so they inevitably will have the criminal screwdriver in you to say, well, you either pay the fines or we're going to, go after you and put you in jail.
Yeah.
So anyway, crazy suit, crazy issue.
And just to put it in perspective, I review 40, 50, 60 suits a week. That's pretty much the limit of what I can do. But I would say each week, maybe every week or every other week, there's a property type of lawsuit involving a fire department. There was one last week on an easement. There's one a couple of weeks ago on a property, another type of property. Somebody was supposed to convey property and it wasn't conveyed. They're not all that interesting. That's why I don't cover them. But it is important for folks to realize that, you know, we're just like any other business, just like a homeowner. In addition to what we do in terms of responding and dealing with our employees, which account for most of our suits, we do occasionally have these kinds of suits. They do crop up. So.
Yeah, well, and so we're going to have a similar property one next, not similar in any way, but it's property. Here we have a homeless or transient individual who goes to this encampment. We're going to be in Oceanside, California now. And it was kind of as it is pictured to me, it's kind of outdoor, wildlandish type area. In any event, there's a fire and the individual dies in the fire, is not found for some time. And the lawsuit, there's a lawsuit against the fire department, which is crazy to me. But there's also against a property owner. Property owner, I kind of understand what they claim, at least. This is just a lawsuit, right? No court decision. But what they claim is that the property was such a fire hazard that should have been cleared, the brush should have been cleared, et cetera. And a landowner may have that duty in California. It's wildfire season. California is a big wildfire area. Maybe they say this is dangerous. On the other hand, maybe the property owner says, listen, we own so much property as a municipality, right? They're in San Diego County. Maybe they say that it's financially unreasonable for us to clear all brush. We can't prevent all wildfires. The difference here is if, people are staying there, I bet there's a heightened duty, I'm guessing in California, to make sure the property's safe. That said, we don't represent San Diego and Oceanside. We want to talk about the fire department's liability. And I just don't see it unless there's some municipal code that requires them to clear the land, which is impossible to imagine. All of California is a wildfire hazard. So I can't see how there's any liability here other than maybe to the property owner, right? Understandably, I could see that.
It wasn't clear to me who was the property owner. I think it was the city of Oceanside, I believe. But it's when dealing with the homeless encampments, like you're in a no-win situation. If you throw them out, you got a problem. If you allow them to stay, but you require them to take certain safety precautions, which they can't afford, you've got a problem. And then if you don't do anything, you've got a problem. And I think that's a classic situation where the public duty doctrine is going to at least become part of the defense. Now, one allegation, and they didn't really sharpen the distinction here, but has to do with them missing the body when they searched the encampment for the fire. They didn't find the plaintiff's or the decedent's body. And, I have a special category on my database for missed bodies, and it happens. It happens at structure fires. This is, I think, the first one I've seen of a wildland fire, or it's not clear to me whether he was in a structure or not. But bottom line is they're alleging that the fire department has some culpability for missing the body, not doing. And
it was the family who found him ultimately when they went back, which is kind of horrible, but not the fire department's fault, probably.
And it's not the first time that we've had family members go in and find a body. It's at a fire where the fire department had looked and the fire department did not find him. So it's not the first time. It's the first one I'm aware of in a wildland environment. Most of them are in structure fires, but.
And hard to imagine there's any real liability for this. Like you said, this isn't like we missed you on a primary search, but even there's not going to be liability. And here it's a huge area. Unless there's any representations, like I promise you he's not here, but what could the damages be? A couple of months ago, maybe you and I had a crazy lawsuit we talked about where a fire department received a dead body and then started intubating it, right? And practicing on it. And they were seeking a lot of money. Okay, I could see that where you're meddling with a dead body. Here, what damages are there? It's not for the death. They couldn't have prevented that, presumably, even if it wasn't their responsibility to clear the land. And so not finding them, what harm is there other than emotional harm? It's hard to imagine there's anything.
They can't get them. It's not intentional. So they're not going to get intentional infliction of emotional distress, but I think they may go for negligent infliction of emotional distress.
Which is very difficult because generally speaking, if you're a bystander, and technically they are, you have to be in the zone of danger, and they weren't in the zone of danger. Very tough case. Very tough case here to win. And look, it's kind of this whole theory of, well, somebody has to pay. It's a horrible thing that happened. I guess I'd turn around to the family and say, why didn't you take them in? Why didn't you provide them a home? Why didn't you keep them out of the woods if you could have, and yet you want to shift your failures to the fire department? That's just not right.
Yeah. Difficult.
It is. Okay, I got to turn this next one over to you because this is as crazy gets. So freaking take it away.
Well, I sort of struggle with what to call the article. I called it "You Can't Make This Stuff Up," Oregon. But bottom line is we've got I'm assuming a relatively small fire district in Tillamook, Oregon. And there's a quote. I start with a quote. Throughout your life, you hear about weird stuff that goes on in small communities and politics and stuff. And here we are. And that was a quote from the chairman of the fire board from the Tillamook Fire District. And I would encourage folks to go to the article that's there. And the author, I'm assuming, is a local person, kind of walks us through the last 18 months of things that have happened in this department. It blows my mind. And some of which I don't even want to describe. I'll just kind of outline what the allegations are. But it starts with some sort of a meeting, a fire district meeting. And I'm not sure if they went into executive session or whatever. One of the firefighters who was in attendance now goes outside the station. And according to the complaint, now we've got 2 lawsuits on it. So, but according to the allegations, and also in the newspaper article, so that's where I'm getting this information from, that this firefighter went outside and urinated. And but the problem was there was a female who was also at the meeting, and apparently, and so she saw him. And there's a factual question about whether he did, whether he didn't. Bottom line is the allegation surfaces and the department suspends them while they're investigating. So and this is just before Christmas of 2021, I believe. So then he is given his suspension is removed, and he's put on probation for 6 months. Okay. So now that was December of 2021. In January of 2022, same firefighter is on probation. During a board meeting, comes into the firehouse, goes into an apparatus bay, and engages in a lewd act in the apparatus bay. Now, I'm sure unbeknownst to him, one of the mechanics, or one of the firefighters, also a mechanic, had several $1,000s worth of tools stolen, and he was concerned about theft. So he had set up a camera.
With permission.
Well, there's a factual question. Again, another factual question. The firefighter claims that the chief had given him permission to film. The chief said, no, I said you could put a camera on the door. I didn't say you could film the apparatus bay. Either way, we have a film now of this a recording. I'm dating myself.
Yeah, I know. Videotape,
film, right? Yeah, right. But so now he's recorded engaging in this lewd act with himself. Okay. So now the chief becomes aware. And by the way, the member then, once he becomes aware of the video, he resigns. Okay. So now the firefighter with the video, lets the chief know, or whatever. The chief finds out, and the chief tells him, you can't share that. I don't want it shared. I don't want it shared. And then because of the lewd act that was recorded, there was a concern about Oregon's revenge porn law kicking in. So he orders there's apparently 2 firefighters now that have access to the video. Somehow the video gets shared. The firefighters who shared the video are claiming whistleblower status because they said, hey, look, we're reporting this misconduct, and now you're going to discipline us. The chief disciplines the two firefighters. Okay. So they end up getting terminated. They go to a law firm, and the law firm files a First Amendment and 14th Amendment lawsuit. Okay. The same law firm also begins representing the female who was apparently the subject of that original firefighter exposing himself when he was urinating. Okay. So now the same law firm is handling both of those. And now the crazy part, one of the firefighters who was terminated is actually the mayor of the town.
It's so much fun.
So now he's upset about getting terminated for being a whistleblower. So he's one of the ones that files the lawsuit. And then he runs for fire district board. There's apparently an opening on the fire district board. He runs and he gets elected.
Of course,
right. And you think that would be enough. Okay. So then the fire chief opts to resign. Now the fire chief is named personally in both of the lawsuits also. So he's got that issue, but he says, I can see the writing on the wall here. He resigns. And then the original firefighter, in the meantime, now 18 months have gone by since this whole, well, 14 months, whatever, have gone by since this happened. The original firefighter becomes a fire chief in another community. And this is all outlined in the newspaper article, the online article that I've got linked there. And then you've got copies of both of the lawsuits that basically are making the same allegations. So you can't make this stuff up.
No.
I mean,
I don't even have a comment.
If you came up in a class and you came up with this fact pattern, people would go, get out of here. There's no way something like that is going to happen. Just incredible. Just incredible.
I'd like to say only in the fire service, but I'm
no,
sure not.
I don't think so. But it is, we don't have a shortage of crazy cases.
Yeah. Wow. Okay. So something that we can more, I don't know, get our hands around. That's unreal. Let's go back to California. This time a little farther away from San Francisco. We're going to go to Santa Monica. And here, I see how this happens. I have one question, and I want to know, which will be, what was the policy, the medical policy? But here we have in April of 22, we have a physician who suffers a ground level fall. I think his wife is also a physician. So you got two physicians on scene. EMS gets called. Look, and you could play this out so easily. They don't take spinal precautions. In fact, the doctor on scene, the wife, I think, tries to say, you need to do C-spine, back pain, spinal precautions. They basically, allegedly, this is all alleged, right? This is all lawsuit, not a decision, but they claim that the EMS told them, go leave us alone, get out, we've got it. And that they, as physicians, that they were relieved of control. I could see how that happens. And that they continue to fail to take spinal precautions. They put the person on a soft stretcher and then sat him up and then laid him down. And all this time he was complaining and in pain. I don't know what they were thinking at the time, but nonetheless, they brought him down a flight of stairs, and it was, jolting him up and down.
I believe they put him in a stair chair, at least according to the allegations.
And it looks like a collapsible one, but in any event, he's going up and down, right? Through his movements, or sitting up, sitting down. The emergency physicians report that he has a very serious neck injury, and basically they ignore him. So at the hospital, he ends up being urgently admitted, taken for surgery on his C-spine. His diagnosis was, in fact, cervical compression and central spinal cord syndrome injury. He's now a quadriplegic. Mm-hmm. So here's the thing. This is what I want to know. Two things, critical things. One, on negligent care, is what was the policy, right? Normally, and look, EMS is getting away from spinal precautions, C-spine precautions, and they're allowing nationally EMS to clear you in the field. Here, you've got mechanism of injury and you've got complaints of pain. So I don't know how anyone could be cleared, right? These are just my questions. But so that's on liability, right? Did they either not follow a policy, or did they exercise discretion? That matters. Was their discretion so likely to cause injury, right? It ignored an obvious complaint. But here's the second part. So it seems like they've got a strong liability case without knowing much more. But the next part is as to proximate cause. Remember, for everybody listening, to prove negligence, a claim of negligence, you got to prove there was a duty and they breached a duty. They may very well have that here if this is accurate. But then the breach of your duty has to directly result in the injuries. I want to know, was he moving his toes, right? Was he able to move his extremities on scene? Because if he was not, then proving proximate cause that your failure to protect the C-spine directly relating his injuries, that may be very difficult. They may, if I'm them, they may, concede to liability, right? And fight over how you're going to prove proximate cause and how do you prove that? Right? Because it's going to be very difficult. So my guess is this results in a settlement up to the insurance limits. And why do I say up to the insurance limits? Well, you've got a physician. I don't know how old he is unless you know, but who's now incapacitated, can't be a physician. Okay, if he was retired, that's one set of damages. If this guy's 40 or person's 45 years old and had another 20 years of practice, we got some big money. The question is, what is the insurance limits? Now we're in Santa Monica. So the insurance limits are the taxpayers' purses, right? You're not broke until your last taxpayer's broke when you sue a municipality. So the insurance will inevitably, I'm guessing, offer their limits. Probably if I had to guess in California, I'm assuming 5 million with a 10 million umbrella, $10 million will probably put up after some discovery and whatever. But my bet is the next thing you're going to see out of this is a confidential settlement. But again, proximate cause is very difficult. If he wasn't moving his toes on scene, how do you prove it? If he was moving his toes on scene, someone's paying a big amount of money.
Yeah, I just don't understand a couple of different parts of this. Number one, you've got a medical professional on the scene. You've got, even if you don't consider the patient, because not really in a position to take responsibility for a patient, but the wife is a medical doctor. And it's inconceivable to me that someone would identify themselves as a medical doctor and the paramedics would say, we're not going to listen to you. Usually the conversation goes something like this: Doc, do you want to take responsibility for the patient?
Yep.
And then you either get a yes or a no, but you don't get, I'm a doctor, get out of our way. It's, do you want to take responsibility? Yes or no. If you don't want to take responsibility, then get out of the way. So I think that's one of the questions that I've got. Now, if the wife is a dermatologist or something of that nature and says, no, this is outside of my area of responsibility, now you've got a different situation. Okay, so that's number one. Number two, it's just inconceivable to me that someone who fell would not have been evaluated for C-spine or some sort of neck and back injury, just based on the end result injuries. It's just inconceivable to me. So I really wonder whether or not factually the complaint is accurate as to what they were told, whether they were basically saying, we don't want any help, just help them get up or something, and that would just get us to the hospital. I really question what actually happened there. It doesn't make sense.
And this is why I like body cams for EMS as well as fire. Fire's a little harder, but EMS, I like body cams because it's just like any other medical situation. He said, she said, what you were told matters. And it's easy to make the fire department or the, paramedics, the bad guys, bad people on this. And I agree. This is so hard to believe it happened. We don't know. We have, right? But even if I was defending this, I'd say, well, prove to me that he wasn't a quadriplegic when you picked him up.
And right. And I think that's what we call causation is going to be one of the big things. Because if the damage was already done from the fall, then what the medics either did or didn't do is irrelevant to his condition. Right.
So it's like dropping somebody with a hip fracture, and the only thing they got after you dropped them is a hip fracture. It's so okay. The next one's just disturbing. It's a lawsuit as well, but so specific, right? So specific and so non-ending that I'm actually going to do what I don't normally do and read about this. And surprising to all of our viewers, guess what state we're in? We're back in California. I'm not sure where this is, where the Rough and Ready Fire Protection District is, but we have a sexual harassment, sexual discrimination suit. This is a California firefighter. She was dismissed from 2 different fire departments. She files suit against one of the fire departments and 3 of its officers. She sues the Rough and Ready Fire District. And she was also a paid volunteer. I guess you mean paid on call, but if I had to guess, but paid volunteer.
That's why I quoted it, because she said, and we know that's, there's no such thing as a paid volunteer. You're either paid or you volunteer. There is no. Yeah.
Which question, it leads you to question the attorney, but what do they know about the fire service? But on the other hand, you don't have to know that much in this case. She was there for 17 years as a, let's say, we're going to assume paid on call, but who knows? And she had been nominated, according to the complaint, she had been nominated for promotion to captain at the Foothills Fire Department. And then her troubles began and spilled over. So here's what happened. She works as for the Rough and Ready Fire Protection District in October of 18. That goes on only until June of 19. Yeah, something like that.
Not all that long. Yeah.
But to the viewers, listen to what happens. This is insane. So a defendant, Hicks, and Hicks is a lieutenant, started engaging in this constant unwanted sexual conduct as soon as White was hired over at Rough and Ready. And I hate that name for this, but I presume it's like a cowboy type thing. In any event, allegedly, the lieutenant would and by the way, lieutenant. So we're talking about a managerial level. So when this happens, you lose. When your managers are harassing your employers, if it's true, right, it doesn't matter what the employer knew. You pretty much lose when your managers are doing it. In any event, the lieutenant would make lewd and sexual comments to her. For example, he would ask her to have sex, would often brag about how good he was at certain acts. He would be allegedly very graphic and vulgar about it. Allegedly, the lieutenant keeps saying, "Show me your breasts," and said that your job here would be much better if you would just show everyone. Apparently, he would make gestures of sexual acts to her. He would make these remarks in front of other people. Now it really gets bad. She always rejected his sexual advances. She asked him to stop, which again, you don't have to do when you have a managerial level person doing it, but nonetheless, he kept doing it. Even after being told to stop, he keeps doing it, and it got worse. She made more verbal and written, she makes verbal and written complaints to the defendant and accusing him of this. And allegedly, they do nothing to stop this, nothing in reaction to these complaints, which again is amazing if true. They don't always know, right? I mean, management sometimes say you don't need to know what I did, you just need to know I took care of it. But that's not what's alleged here. What's alleged, at least, is nothing happened. In any event, after numerous complaints, she gets laid off. So now we enter a retaliation phase, right? And she's, yelled at this point. She's told to get the F out of the station. She's really being retaliated against, allegedly. And ultimately, it keeps going on, right? So Hicks, the lieutenant, alleges that the plaintiff had suicidal intentions, was a danger to herself, right? He's trying to get her detained. All series of retaliations are going through this. All these false claims keep coming up. In any event, she's now not promoted, right? And instead of being not promoted, just simply not promoted, she's told to step down from her position. I think is lieutenant, but she's told to step down.
That's in the other department. So that's
right.
Yeah, that's in the other department.
So it spills over. They retaliate, it sounds, allegedly, for something that happens in the first department. I don't know whether you can see this happening or not. She claims it did. So last week, I think we had a $250,000 settlement. And I think my comment was, look how little happened that results in a $250,000 settlement. This, if it's true, is going to rank in the millions. I mean, but for a settlement. But this is constant, so alleged to be constant, severe, pervasive, claiming somebody, all this retaliation, that they're suicidal. I mean, this is really very serious stuff. And now you bring in a second insurance policy, i.e. a second department where they're allegedly retaliating, saying you didn't get the promotion. That's hard to prove why you did or didn't. But, the he said, she said here on what happened. And the fact that what I read, what was key is it happened in front of other people occasionally. So, you'll see, it'll be a factual dispute. What did you report? Who knew what? What did he really do? What can you prove? And did you really file a written complaint? And once you did, which I presume she did, that's nobody would make that up, I presume. But then what happened after the written complaint? Did they investigate? Did they find out anything? Did they interview all those other people who allegedly saw some of this happening? Was there a 911 call or a report of her, alleged suicide? These are things that are easily able to be verified. So this could be a big, this is one of those things that gets settled, and people get fired. A lot of people will get fired.
This is not the only case that I've seen in the fire service where people have reported other people for having either psychological issues or being suicidal, and not in an attempt to get them help, but at least as this is alleged, the idea here is to sort of further the alienation of this person from the rank and file. And that's what is being alleged here, that there was no genuine concern about her safety or her psychological well-being. It was more about, trying to tarnish her reputation, and which apparently it was successful. She not only lost the job with the Rough and Ready Fire Department, but she also ended up losing her position with the Foothill Fire Department. So definitely a fact pattern that it concerns me. I've seen it before. And I think when someone is genuinely concerned about someone being suicidal, that's one thing. But when you start looking at a retaliation situation, and then you're using that on top of already retaliating against somebody who's made complaints against you personally, this, I agree. This has the potential for a pretty big payout. God help them if they want to go to trial on it.
Oh, yeah, no. And they could have added more. They could have added ADA with a parent disability. I mean, there's a lot of things they could add in here. I don't think they need it, but they got enough. But man, you could bring a lot of other laws in here. But in the acts of harassment and bullying, we know, that those have long-term effects on people. So now she's going to get her job back. Let's presume he's going to get fired. If
she wants it back, but
well, and that's the problem, and who would want to go back into that? It wasn't just Hicks, allegedly. It was the other members of the department did nothing. The leadership did allegedly nothing. But this is ugly. And, the real question, though, is what do you get as a volunteer? On the volunteer side,
damages. That's what are your damages? Certainly your reputation and psychological well-being, medical bills for psychological counseling, that type of thing. But, in terms of lost wages.
Right. There's just not that much there. Yeah. Doesn't mean there's not the let's call it the punishment money, right? That courts could give, not just punitives, because you don't always get those against municipalities, but they always have ways to say, we're going to hit you for this money. Any event, this was an interesting week. This was definitely one for the records, I think, with some of these things that happened.
There was one more case, not that, we have to get into detail about it, but it'll be in my newsletter that goes out tomorrow. But I understand Kitty ended up filing bankruptcy. Kitty is one of the AFFF manufacturers, and with the PFAS lawsuits, they're, at least as far as I've been tracking, they're the first of the AFFF manufacturers to go bankrupt. I did get a look at the complaint, and it said that right now they're facing over 4,000 lawsuits.
Wow. Wow.
4,000 lawsuits on the AFFF PFAS issue. So we were wondering, I know you and I had speculated as to how many suits had been filed, and in their bankruptcy pleadings, they're facing over 4,000 lawsuits. So,
Jesus.
yeah.
Incredible.
So,
Okay.
all right, well, that'll do it for another edition of Fire Law Roundup. If you haven't clicked like, please do, and please click share, and please subscribe and help us get our numbers up where we need to be in terms of number of subscribers, but we're always looking for more. More is better. We need more hours. I think we're now about 400 hours short. So we need an extra 400 hours of watching. And so if you want to do some binge watching, the holiday is coming up, right? Memorial Day is coming up. So feel free to do some binge watching, help us get our hours up, and help us move to the next level with YouTube. Okay. And that's going to do it for another edition of Fire